Hello everyone, welcome to Legal Darshan. In today's video, we are going to discuss case number 85 in the list of AOR leading cases, and the case goes by the title Property Owners Association and Others versus State of Maharashtra and Others. Now, this particular case deals with one important article, Article 39 of the Indian Constitution. Now, we know that Article 38 and 39 are the articles that promotes the distributive justice the most in the Constitution of India. Now, when we look at interpretation of Article 39 Clause B with respect to property allocation, with respect to material resources be allotted in a manner that it subserves the maximum good, that interpretation is in question in this particular case. Now this case is also dealing with Justice Krishna Iyer's verdict, which was given by him in the Ranganath Reddy versus Karnataka and Sanjeev Coke case, and also the same kind of finding was validly upheld in Mafatlal versus Union of India as well. Now, in this case, the court is revisiting the interpretation of Article 39B as taken by Justice Krishna Iyer, and the court is reconsidering such argument because such decision, because Justice Krishna Iyer has given such a verdict in a constitutional bench, and therefore in this case a 9 judges bench is being formed to adjudicate the issue. Now the main issue, when we before coming to the main issue, right, we come to the Article 39 first. Now your Article 39 says that Article 39B is in question. We need to understand Article 39B first, and then we will go to the case back. Okay, so Article 39 is saying that there are certain principles of policy that is required to be followed by a state in order to promote a welfare state. It is given in the directive principles of the state policy, and the case and the 39B is the state shall in particular directs its policy towards securing that the ownership and control of the material resources of the community are so distributed as to best to subserve the common good. Okay, so now this is basically a principle of distributive justice, that the material resources of the community are controlled and are owned in such a manner that they serve the common good. Okay, now this we also called as res communis. One doctrine comes to my mind when we are discussing it. Res communis, that there is a belongingness of the community with respect to the material resources available in the community, that they belong to all and that they serve the common good. Okay, now the question that arises in the case of property owners versus state of Maharashtra is that when we talk of the material resources of community, okay, so what exactly is the material resource of community is under that deliberation in this case. Okay, so material resource of community, the moot question is that does it includes public property, it includes, for example, lakes, rivers, properties owned by the government, but does it includes the private properties as well? That is the question that is arising before the court in this particular case, right? So we will just come back to the judgment now. The first issue in consideration is that when Article 31C was struck down, which is also whether that article survives in the constitution even after amendment by way of 42nd amendment, even after amendment when even after amendment to the provision by the 42nd Amendment Act was struck down by the Supreme Court in Minerva Mills. That is one question. And question number two is whether the interpretation of Article 39B as taken up by Justice Krishna Iyer in Ranganath Reddy's case and followed in the Sanjeev Coke case, can it be reconsidered, and whether the phrase material resource of the community in Article 39 Clause B can be interpreted to include resources that are privately owned and are not owned by the state, right? So this is one issue that we need to examine in this case. Right now we come to now this judgment is a 9 judges bench decision, and it is being decided by a majority ratio of 7:2, 7 being the majority verdict, and it is being authored by Justice DYC, whereas the Justice DY Chandrachud, and this dissenting opinion, okay, the opinion the dissenting opinion is given by two justices, one Justice Nagratna and another being Justice Dhulia. Right, so we will discuss the dissent as well, because this question is an important consideration. It is a question of important consideration with respect to distribution of resources in the community. Right now, when we look at this case, okay, so when we understand this case, basically we need to go into the history as well, that why this case is arising. We need to first understand that. So basically what happens that in Maharashtra, the Maharashtra government passes an act. Now that act is named as the act enacted an amendment, which is Chapter 8A of the Maharashtra Housing Area and Development Act. It is a 1976 act, and the so-called Chapter 8A, allowed the state to acquire old buildings in Mumbai for redevelopment if 70% of the tenants, if a number of the tenants consented to it. Now the aim of this law was to implement Article 39B, so that the state acquires the ownership and control of the material resources and can distribute to serve the common good for with respect to those properties. Now the property owners of those buildings in Mumbai, they are challenging this provision, saying that it is their own property, it is their private property. Why the state is acquiring it in the name of redistribution of the owners in the garb of Article 39B, and they are arguing that it is infringing my right to keep my private property without adequate justification. The contention of the petitioner is such that my right of keeping my own property is being infringed by such a step that is being taken by the government, whereas the stance of the government in this case is that we are acting in the light of Article 39B, which ensures that state can make policies for taking ownership and control of the material resources that are distributed to serve the common good. Okay, now we come back to the first question, whether Article 31C, which protects implementation of certain directive principles from being challenged for violating fundamental rights, is it still valid after the Minerva Mills decision? Now the court is saying that regarding 31C, we will wind up the first issue and then they will elaborate the second issue. Court is basically saying that regarding the first issue, Article 31C, court affirmed that it exists in the constitution as it is upheld in Keshwaran Bharati versus State of Kerala. But the protection that is given under Article 31C will only be applied to laws implementing Article 39B and C and not all other directive principles, which also was a stance that was taken in Minerva Mills also. Now, when we come back to the second question of this particular case, it is that whether Article 39B permits the state to acquire privately owned properties as material resource of the community. So can material resource of the community include privately owned property? That is what the Supreme Court is looking in this judgment. Now, one thing that is being held by the majority opinion in this judgment is that not all property qualifies to be material resource of the community. Only those resources which meet a specific criteria, for example, nature of the property, impact of the community, scarcity of that particular property, that depends, or consequences of private concentration. So for example, if there is a well in the village, okay, now that the purpose of that well is to serve water to everyone, but when some people on customary basis or on any basis, they hold the right ownership, though they do not have it, to the aspect that, to the extent that there is a private concentration of the resource, of the water resource, of the well, then that can be taken away by state can claim the ownership back and redistribute the common good coming out of it. But court herein is saying that not all property qualifies as material resource of the community, and it does not include, okay, now this does not include privately owned properties. it is being emphasized that Article 39B is not a blanket authorization for the state to acquire private property. Instead, each case requires a context specific analysis, because you cannot say that private property will fall in the ambit of material resource of the property, because if having done so, there will be a violation of the property rights that vests with people. Okay. Now the court is basically saying that, does it include article 39, does article 39B include privately owned resources? If you go into a literal interpretation of article 39B, the answer might be yes. Theoretically we might say it's a yes, and phrase may include private property owners, as it was also a consideration, as it was also a judgment that is being given by Justice Krishna Iyer in state of Karnataka versus Ranganath Reddy, and also in the case of Sanjeev Coke Manufacturing Company, which is endorsing the views given by Justice Krishna Iyer. Now, court herein is saying that we are unable, the phrase theoretically may, encompass private property, but the 7 out of 9 judges, they are, unable to subscribe to the expansive view that was adopted in the judgment authored by Justice Krishna Iyer. Now, even though the judgment that was given by Justice Krishna Iyer in state of Karnataka versus Ranganath Reddy was a minority verdict, it was relied on subsequently in the case of Sanjeev Coke Manufacturing versus Bharat Coking, right? Now, then that became the norm, that became a judgment of the Supreme Court, right? Now, not every resource owned by an individual, it can be said to be a material resource of the community just because it is meeting material needs. Okay. Now, this is the substance that is held in the judgment authored by Justice Chandrachud. Okay. Now, he's also saying that the inquiry on whether a resource is a material resource of the community, it should be done on the basis of some elements which could be nature of the resource, like for example the well example I was giving, that there is a well, people are using it to fetch water. That what is the nature of the resource, what is the characteristic of the resource, what is how is that resource giving the output, how is that resource beneficial for the well-being of the community, whether that resource is easily available or whether that resource is scarce in nature, and what happens when such kind of a resource gets concentrated in the hands of private parties, or get monopolized by private persons. That is what the court has to look in. The court is also taking the shade of public trust doctrine, that you can also invoke public trust doctrine to identify if these are the objects that needs to be material resources under article 39B. Okay. Now, public trust doctrine is one doctrine that developed in the environmental law discourse, environmental law jurisprudence, and this has been invoked in MC Mehta versus Kamalnath case and many such cases, right? So, now what is happening, that there are various forms of resources. Now, material resource is not coming with a qualifier. Okay, but it is material. Now, material can be anything. Material can be something personal. Material can be something professional. Material can be a building. Material can be a car. Okay, so there are many forms of resources which can be privately owned, and they have some kind of bearing on community, on how a community is kept in a sound situation. Okay. Now, such resources, those resources which have a bearing on the well-being of the community, they may fall in article 39B. Okay. And this could include some forest, some ponds, some lakes, some wells, some natural gas, coals, mines, minerals, which are scarce, and but they are fine, which are scarce and finite, and they are not in abundance, and can sometimes be within private control. Okay. So in those cases, we can crystallize them under Article 39B. We can give, state the power to make policy under Article 39B. But when we talk of the term distribution, right? So now, there are various forms of distribution that can be exercised by the courts. So that is on the distribution aspect, Justice Nagratna is basically pointing out her dissent. Now, when we talk of distribution of the, resources, Justice Nagratna is basically saying, now Justice Nagratna is taking up on building up on the verdict of Justice Krishna Iyer, which was given in the previous cases, and Justice Nagratna is not not in she's not conquering, she's not in consonance with the view that is being taken by the majority opinion in the in this case with respect to second issue, not with respect to first issue. So with respect to second issue, Justice Nagaratna is basically distributing the resources into two material aspects. One is the resources that have personal effect, that have an essence of personal belonging. So jewelry, my jewelry that my mother gifted me, my household articles, my clothing, my utensils, my kitchenware, my jewelry, my clothes. These things could belong to an individual. My books also, these could be intimate, okay? And these are personal in nature and use. But if there is if you cannot attach personal effect to an entity, if you cannot attach personal effect to a material resource, then that all the other resource to which you cannot apply personal effect, they will be construed as material resources in the light of article 39b. Okay, so my house or my building or my land, that might be considered a material resource even though it is privately owned as per Justice Nagaratna. So she is siding with Justice Krishna Iyer's view that has been taken up earlier, whereas the majority opinion is not willing to stick to it. Okay. So now Justice Nagaratna is basically pointing out that all the resources, whether they are public or whether they are private, if it comes within the ambit of material resources based on the classification she's providing on personal effect, that resources will be falling under material resources if they do not have a personal effect. Okay. Now, private resources, she is telling that it can also be turned into material resources of the community, for example, by the means of nationalization. There was nationalization of banks earlier for by acquisition. So there is acquisition. We see acquisitions these days. Then there is by operation of law also. Maybe some by operation of law or some kind of purchase that state does. Okay, we see that state acquired land sometime, land acquisition laws we do have. And then owner's donation also is one way that if I am donating my property to charity, then that could be one way that private resources becomes the material resources. Now she is also emphasizing that distribution could be in two ways. One is that the state retains the material resource. Okay, now how do state distribute the material resource? The state retains the material resource. For example, there is bus, there is cars, there are shuttle buses, there are public vehicles, right? So these kind of material that are being retained by the state for public purpose, okay, for maybe making sanitary services available on the roads. These are the way that government is distributing the resources. And second way is that privately owned material resources, when they are converted to material resources of the community, these can be distributed to eligible person or the needy persons by way of lease, sale deed, by way of some kind of grant, some kind of auction or anything, by any mode of transfer which is valid in the eyes of law. Can be temporarily, can be partially, can be permanently, can be conditionally or unconditionally as well. Okay, now she is basically relying on the opinion of Justice Krishna Iyer, and so according to her, the law that has been taken up in Sanjeev Cook is a good law insofar. Justice Dhulia's opinion is also in line somewhere with Justice Nagaratna, and he is emphasizing now what Justice Dhulia is emphasizing here is that there is political and economic inequality that are existing, and political to curb those social, political, and economic inequalities. Such kind of uh, to maintain that kind of equality, such kind of law has been, put in the Constitution of India. So there, thus, the the width between rich and poor, there is a growing gap, and it's enormous. Okay, it's a growing gap, and it's not prudent, it's not correct, it's not, right, if we just drop 38 and 39, and which are the important provisions in the Constitution of India, and which stands the three judges opinion, which, upholds the three judges opinion that was given by Justice Krishna Iyer in Ranganatha Reddy's case, right? So now with these two judges dissenting, the majority opinion holds that private property anyway will not be considered ipso facto as a material resource of the community. We need to check the parameters. For example, we have discussed the nature, impact on the community, how it is placed in the society, etc. Right? So this is it. This was the main issue that has arisen in this case and has been decided by the court. Now, the scope of Article 39B is being clarified in the judgment, ensuring that not all private properties can indiscriminately or by ipso facto acquired by the state. Okay, it is reinforcing and balancing. It is harmoniously construing the socio-economic rights of the people, the principles of res communis, along with the protection of property rights for the individuals. Now, Justice Nagratna's dissent is also an intervention. Justice Dhulia's dissent is also an intervention here. Both the dissents are an intervention here, which is highlighting that there is economic imbalance existing, economic inequality existing in society, and to curb those inequalities, to fill the gap that exists between rich and poor, we do need provisions like 39B in our social legal framework. So this is it for the judgment. I hope the discussion was useful. Thank you everyone for watching. Please stay tuned with us on Legal Darshan. We will be uploading more videos in a very quick while. Thank you everyone. Have a nice day.